I'm going to try to do, I suppose, tonight is to give you an overview of bankruptcy, something I've been practicing law in for 35 years. And to do that in 50 minutes is going to be rather difficult. But bankruptcy began really with the idea back in colonial Williamsburg that we shouldn't have English prisons here in this country. It was actually established in the United States Constitution in Article 1. We never got around to creating a bankruptcy law until the late 19th century. We didn't even create a Chapter 9 bankruptcy until 1933, when it was first declared unconstitutional by the United States Supreme Court. When Franklin Roosevelt repositioned the Supreme Court, the 1937 law was approved as constitutional. Since that time, we've only had about 500 Chapter 9s in the entire United States. So it's not an area that is well understood.
And Robert?
Yes.
What's Chapter 9?
Well, there are different types of bankruptcies, and they are all known as chapters. We have Chapter 7, which is for individuals and corporations. That's the true bankruptcy. It's a liquidation process where you give up your unprotected assets and be excused from having to pay dischargeable debts. Chapter 11 is the classic business reorganization that companies such as Levitt's has done, United Airlines, Northwest Airlines, I think Sharper Image entered Chapter 11 today. And it goes on and on and on. Chapter 9 is strictly for municipalities and governmental organizations. Those that have done that are probably more well known include the County of Orange in 1994, the City of Bridgeport, Connecticut, an Alaska School District, a Richmond School District, San Jose Unified School District. So there have been Chapter 9 procedures. And then we have Chapter 11s or Chapter 12s for family farmers, 13s for repayments, and Chapter 15s for international conglomerates that have business dealings in the United States. And the way it works is a municipality has to be eligible to file a Chapter 9 to start with. And eligibility is defined under the bankruptcy code as being unable to meet your debts as they come due. There are different definitions of insolvency in other chapters, but for Chapter 9, that's the threshold. There also has to be an authorization given to the municipality by state law. Not all states permit their municipal organizations to file. Iowa and Georgia do not. California does. And so that's one reason why I think you see many filings in California, plus we're always on the cutting edge. We're ahead of everybody else, and I think we're no exception here in Vallejo. Another requirement is that there must be a desire, a genuine desire to effect a plan to readjust your debts. And of course, this brings in a concept of good faith. I'll be using that phrase a lot tonight, good faith. It's a very subjective evaluation, but it's always present in any type of bankruptcy law. Then the last requirement is one of an alternative possibilities. One is you can get permission of all of your creditors. That would include vendors who are selling supplies to the city of Vallejo.
You might want to pull it up to your mouth.
Okay. That would include vendors who are selling to the city of Vallejo, union contracts, bondholders, both special and general, anybody who has a claim against the city of Vallejo for money owed. If you can't obtain that general consent before you file, then you have to negotiate in good faith and fail to have reached an agreement. And there's that phrase again, good faith, and I think that's what we're doing right now in this week before we lead up to February 26th. As you know, there has been a lot of challenges and counter positions taken by the unions and the city about whether or not everybody's divulging true and accurate information, what the true status of our financial condition is. Well, a lot of that is posturing, but now that we're getting to the point of either filing or not filing, I think you're starting to see some meaningful discussions. One of the important distinctions between a municipal bankruptcy and a reorganization, a business reorganization, has to do with those negotiations. In Chapter 11, if the judge doesn't think the people have negotiated sufficiently, he's going to send them back to the bargaining table. Now, in Chapter 9, that authorization does not exist as a statutory permission, but I'll bet you anything you'll see a judge saying, well, I think good faith requires you to do X, Y, Z. And the power of a bankruptcy judge is huge. Bankruptcy judges are appointed by the circuit in which they sit. We're in the Ninth Circuit. And an interesting thing about Chapter 9s is that when a case is filed, it's not given to a sitting judge in the area where you file. We live in the Eastern District of California. People who live in American Canyon or in the Northern District of California, they go over to Santa Rosa. People in companies in Crockett go down to the Northern District in Oakland. We happen to be in the Eastern District in Sacramento. There are 4 sitting judges in Sacramento, but the new law permits the circuit judge, the chief judge of the Ninth Circuit, to designate which judge will hear the case. It will not probably be given to one of the 4 sitting judges. Instead, the circuit judge, Judge Kaczynski, will designate somebody. It might be a retired senior judge, and I can think of a couple of them in Sacramento that are fully capable and qualified to do this type of a job, or he might bring in somebody from Idaho or Southern California. Judge Kaczynski is very involved in the bankruptcy process. He's the one who wrote a standard that requires good faith in the Western United States. That standard is not prevalent throughout the entire country, but it was in the United States in the Western Division because he had a case before him where, once you know it, a lawyer out of Arizona kept trying to prove he was right, and in so doing took himself all the way up to the Ninth Circuit where he continually lost, and the judge just called him to task for these antics and said, we look at what you have done before you have filed. We look at how you've handled your affairs. We look at whether or not you're a good person, and if we think you're not, we're throwing you out of here. And that's what a bankruptcy judge in a Chapter 9 has the power to do, to throw you out. When the case is filed, you present a petition. And it's a compilation. It's like a legal inventory of everything you own, everything you owe, and a lot of background information. It's all filed and becomes a public document. It will be accessible over the internet. Anyone can look at it. Then, as soon as the case is filed, the court issues something called an automatic restraining order. It's an injunction. It says, time out. Nobody gets to collect anything, including raises that are due but not yet paid. So it puts everything on hold for a while, and then you have to publish a notice in the newspaper once a week for 3 weeks. The judge will tell us where to publish the notice. It's really designed to give notice to the bondholders because one of the most important players in this procedure are the bondholders of the city of Vallejo, the ones in New York. And they're going to have a significant involvement in this process. Everybody's going to have, including citizens. You have the right as a citizen to speak to the bankruptcy court. And that's a very unusual departure in bankruptcy. I can just imagine a designated judge hearing some of the people who appeared at city council in the manner they've appeared, giving them their thoughts. So perhaps instead of having a one-by-one basis, may I suggest that at this time there be an organized effort, a citizens committee who will study this process, who will formulate recommendations, because as a designated committee, I think you'll have a greater ear before the bankruptcy judge. I think he'll listen to somebody who comes forward in a meaningful manner and is intelligent and articulate about